Greetings, this is Christine Van Pelt on Gibson County, Indiana, and we are continuing with Brent Allen Winter's Declaration of 76, United States Constitution. Common lawyer comments clause by clause. You can purchase the book and study guide at commonlawyer.com. He has other study materials there that are very useful for us in common law. He does live Terre Haute, Indiana, so support him. He has not presented paperwork to the Indiana Assembly, but he has done a lot of this core counselor training. So we'll go ahead and move forward with the reading. Amendment 6 in general. Comment. The rights Amendment 6 guarantees are all fundamental and of equal dignity, but never explained. So also, for example, our Constitution guarantees the right to trial by jury. But like Magna Carta, never explains it because the people were wholly familiar with their right to jury by trial. From the Norman peerage to the Anglo-Dane tenant farmer and the colonial freeholder. In fact, all had either taken part in a jury trial or knew someone who had. Likewise, the colonial was familiar with the 7 rights Amendment 6 lists. Declaring respect for another's fundamental rights and knowing how to go about doing so are two different things. For example, under pressure to make a show of fairness, civil law countries around the globe now declare they allow the right to trial by jury. But in every case, the government, by clever devices, renders the jury powerless. Further, in civil law countries, jury trial is never a right to be enjoyed upon demand, but a mere privilege from the state. Window dressing to pacify the public's need to feel that government is fair. By contrast, in our common law country, one enjoys trial by jury by right on demand, not by mere request. In fact, to enjoy the right, the plaintiff in a non-criminal case must demand trial by jury in his first pleading. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Comment. Because entwined in practice, Amendment 6 rights, like Amendment 1 rights, are of equal dignity because they stand and fall together. For a court to demean any one demeans them all. The right to a speedy and public trial is the common law's weapon against government's jailing of those of whom it, in ever fickle whim, disapproves for as long as it likes. These two rights are as fundamental as any other right our Constitution guarantees because, among other reasons, jail, whether before or after trial, is abhorrent to the common law tradition, and secrecy in government tribunals is a guarantee of forgetting jailed defendants. Where trials are public, however, such abuses are reduced. The right to a speedy trial has 3 purposes. 1. To prevent long jailing prior to trial because once jailed, the accused and his plight is easily forgotten. 2. To lower anxiety accompanying public accusation. And 3. To keep long delay from weakening the accused's ability to defend himself. Smith v. Huey, 393 U.S. 378, 1969. The speedy trial right is fundamental because without it, the freedom of every defendant awaiting criminal trial, whether jailed or bailed, is disabled. Mere indictment will subject him to public scorn and deprive him of employment and force curtailment of his speech, associations, and participation in unpopular causes. Prolonging this oppression, as well as the anxiety accompanying public accusation, denies the petitioner the right to speedy trial, which is guaranteed to him by the 6th Amendment. We hold here that the right to a speedy trial is as fundamental as any right secured by the 6th Amendment. Smith v. Huey, 393 U.S. 378, 1969. The Amendment 6's speedy trial right says the Supreme Court traces to the Anglo-Danes common law, "We will sell to no man, we will not deny or defer to any man either justice or right." Magna Carta, Chapter 29, 1215. Sir Edward Coke further explained this common law principle, writing that late 13th century English judges have never suffered the prisoner to be long detained, but have given full and speedy justice without detaining him long in prison. Magna Carta, says Coke, guarantees trial speedily without delay, whether free or bond, man or woman, or old or young, outlawed, or any other, without exception, freely without sale, fully without denial. See Klopfer v. North Carolina, 386 U.S. 224, 1967. Every law student in the American colonies read Coke's works. Thus, the Virginia Declaration of Rights of 1776 echoes Coke's take on Magna Carta. In all capital or criminal prosecutions, a man hath a right to a speedy trial. That this right was considered fundamental early in our history, as is shown by its guarantee in the constitutions of several of the states of our new nation, as well as by its prominent position in Amendment 6. Amendment 6. Today, each of the 50 states guarantees to those it accuses of crimes the right to speedy trial. To sum up, the history of the speedy trial rights reception in our country established it among the most basic common law rights for our Constitution. Common law rights our Constitution preserves. Moreover, the right to a speedy trial is a matter of due process. If too much time passes before trial, evidence grows stale or is lost, and sham proceedings replace due process. The right to a speedy trial, says the Supreme Court, is not a theoretical or abstract right, but one rooted in hard reality in the need to have charges promptly exposed when the case is fresh. The Speedy Trial Clause spares the accused those disabilities which are also incompatible with the presumption of innocence which delay causes. These disabilities can impair the accused's abilities to mount a defense. The passage of time may dangerously reduce his capacity to counter the prosecution's charges. Witnesses and physical evidence may be lost. His own memory and the memories of his witnesses may fade. When the fact at issue is as subtle as a mental state, the difficulty is enhanced. Dickey v. Florida, 398 U.S. 42, 1970. All Amendment 6 rights to a speedy and public trial, to an impartial jury, to be informed of the charges, to confront accusers, to compulsory process, to obtain witnesses, to counsel, to the presumption of innocence, and proof beyond a reasonable doubt are so fundamental that the defendant, in order to get relief for his having been denied any of these, need never show that the denial hampered his ability to defend himself. In fact, where an Amendment 6 right is denied or violated, law requires no showing of injustice or injury, deeming injury to the defendant foregone. See this Handbook U.S. Declaration of 76, 17, 20, and 20 to 21 in comments. Criminal defense lawyer Christopher Donovan of Milwaukee, Wisconsin, provided the research for the foregoing comment concerning the right to a speedy trial. Right to a public trial. Comment: secrecy in its crafts, e.g. backroom confessions and the confessional, have enabled the evils of all false religion, law, and government since early Babylon, reaching its zenith at Rome. Under Roman civil law and systems derived from it, a trial, even today, is an inquisition. The judge makes his own investigation, which is uncontrolled. The suspect can be interrogated in private. He must answer all questions. His right to be represented is restricted. The witnesses against him can testify in secret, and in his absence, thus often arises secret intimidation, enforced confessions, torture, and blackmailed pleas of guilty. Churchill, 164. By Amendment 6, the framers intend to bar the civil law tradition from our courts because it has secrecy for its foundation, deceit for its rule, confession and conspiracy are its darlings, torture and death, and threat of the same its ready tools. Whereas the civil law is largely written, secret, non-confrontational, and confines all consideration to its code, causing facts to recede from consideration, common law trials are oral, spoken, public, confrontational, and fact rigorous. Acutely aware and zealous of these differences, the framers demanded public trial, which includes, says the Supreme Court, all pre-trial hearings. Our right to public trial is coextensive with the right to freedom of speech and freedom of the press. Trials must be public so the people and press will have free access to hear and discuss freely. In fact, a public trial must by definition be spoken because it is before the jury. Further, common law has as a rule, bars ex parte, one party, hearings because such hearings forfeit the power of adversity to uncover truth before the public. See this handbook, U.S. Declaration of 76, sections 17, 20, and 21, and comments. Nowadays, however, prosecutors in American courts deny with high-handed impunity the right to a speedy and public trial, where even some judges, in callous disregard of due process's fair play, brook secret proceedings and sealing of court documents. To sum up, this public trial clause is meant to prevent civil law's inquisition in America. In the inquisitorial court, the roles of prosecutor, defender, and judge are combined in one person or group of persons. It holds its sessions in secret. The usual explanation is that the methods by which it extracts confessions could not stand public scrutiny. But the reason runs deeper. The methods employed by an inquisitorial court could scarcely be the subject of meaningful observation by an outsider. It is only when the roles of prosecutor, defender, and judge are separated that a process of decision can take on an order and coherence that will make it understandable to an outside audience and convince that audience that all sides have been considered. Fuller, 35 to 36. Amendment 6 continued. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Comment. Because the common law tradition is grounded in local land use rights, it keeps government power under control of neighbors, peers, and elected county recording clerks. In fact, the common law demands local trials before local jurors. Close by, where the acts complained of are said to have been done so that witnesses and other evidence is available. Our declarations, Clause 21 says King George conspired. He has combined with others in order to transport us beyond seas to be tried for pretended offenses. In addition, Clause 6 charges him with calling together legislative bodies at places unusual, uncomfortable, and distant from their public records for the sole purpose of fatiguing them into compliance with his measures. Bottom line, King George and his cronies were trying to replace the common law tradition with admiralty law, a species of Roman civil law, governing by distant decrees from a faceless power and carrying away those it accuses of crimes from their neighbors, their peers, to be tried before distant and strange judges. Civil law's trial by government instead of by one's country, jury trial, In order for a jury in a criminal case to be impartial, fair, he must never be a government hireling, a member of the prosecuting party, or the defendant prosecuted party. Thus, in criminal trials, common sense disqualifies government employees from jury duty because such a defendant will favor government, his provider. Moreover, the people lose confidence in courts that use such biased jurors. The mere appearance of bias, says the Supreme Court, is bias. Hence, an office holder, agent, or otherwise government hireling is incompetent to be a juror in a criminal trial. If such a person is called to jury duty, good sense demands that he tell the court of his bias. Further, concerning the right to trial by jury in a criminal case, the Supreme Court says that a judge is an employee of the state and therefore never to be entrusted with a verdict for the accused without his waiver. Why? Because the judge's provider is a party to such a case. Just as our common law entitled Anglo-Saxon nobles, athelings, to trial by a jury of peers, other nobles, it entitled the plowman to trial by a jury of his peers, honest farmers and plowmen of his countryside. See this handbook, U.S. Declaration of 76, clauses 17, 20, and 21, and comments. See also Brent Allen Winter's Juror's Handbook of Common Lawyer Comments discussing Magna Carta's common law meaning of the word peer. Amendment 6 continued, and to be informed of the nature and cause of the accusation. Comment, this clause requires that a criminal complaint tell the defendant the time, place, and act of which it accuses him. Only by knowing the details of the act of which he is accused, the charge can be prepared any meaningful defense. Can he prepare any meaningful defense? Civil law is law-driven. The government's legislative will controls. Common law is fact-driven. The facts control. Thus, to ignore this clause violates due process. Parroting the language of the statute of the defendant, the defendant is accused of violating is not enough. The indictment must set forth what act he did to violate that statute. A defendant's motion for a bill of particulars can remedy a criminal complaint falling short of the defendant's right to be informed of the nature and cause of the accusation. See this handbook, U.S. Declaration of 76, sections 20 to 21, and comments. Amendment 6 continued. To be confronted with the witnesses against him. Comment, this confrontation clause guarantees the common law's due process right of cross-examination. A duel between the examiner and the examined. Going under oath, a lying witness opens himself for punishment if caught lying. Going under cross-examination, he tries to evade capture. The term confrontation has specific meaning at common law. It requires that the judge give the defendant opportunity to cross-examine each witness that testifies against him. As often as not, such a witness is not the defendant's enemy, but someone whose testimony of otherwise harmless facts the prosecutor wants to twist against the defendant. At bottom, the confrontation clause ensures that the defendant has a go at cross-examining every witness the prosecutor questions. Beginning with the Norman invasion of 1066 and until the common law's resurgence in 1688, English courts resisted the right of legal counsel to those accused of treason and other felonies. Then after Parliament deposed James II, courts recognized not only the right of the accused to counsel for his defense, but also his right to examine witnesses, but still barred him from addressing the jury. To compensate, defense counsel began using leading questions to stretch the defendant's right to re-examine witnesses before the jury into the right to cross-examine. Debarred of one means of advocacy, says Stryker, they sought another, and their cross-examination therefore tended to become a speech in the form of questions, and it has ever since retained this character. Cross-examination seeks simple admission. The questions eclipse the answers. Cross-examination is a creature of the common law, the child of its adversarial personality, grown to strength, under skilled command, the fearsome foe of falsehood and false friend of truth. Beyond any doubt, says Wigmore, the greatest legal engine ever invented for the discovery of truth is cross-examination, by which the witness box becomes a crucible for refining the silver of truth by drawing up the dross of falsehood. Due to its power to purify testimony, says Cox, cross-examination has always been deemed the surest test of truth and a better security than the oath. The oath, with its solemnity, is a reminder to awaken scruples, inciting the desire to let loose the truth, and cross-examination can draw out and lay bare that truth before the jury. Super and Allen Winters, Excellence of the Common Law, subsection 5.1.5.4 for examples of cross-examination. Further cross-examination tests not only the one upon whom the oath has taken effect, but also the rascal upon whom the oath takes no effect. The rascal, being without active conscience, has no intent to tell the truth. The sincere witness, even though having intent to be truthful, is often hampered with faulty perception or memory, misunderstanding, bias, or the obscuring effects of time. In sum, human weaknesses erode testimony, most of which fall short of the whole truth. The common law acknowledges such weaknesses in both honest and dishonest witnesses by recognizing that cross-examination is necessary to uncover truth, the ever-elusive fugitive. Cross-examination tests the witness's awareness of facts gotten through his senses: sight, hearing, taste, touch, or smell. It seeks to uncover contradictions and improbabilities of his earlier testimony, or to trap him into admissions that weaken it. As a rule of good cross-examination, the cross-examiner must know the answer to the question he asks. Nonetheless, as long as he has some basis in fact for his asking, the common law allows him to ask leading questions, suggesting, even providing the answer, most often leaving nothing for the witness to do but agree or disagree, answering yes, no, or I don't know. The rules of cross-examination limit its questions to matters opened on direct examination. By contrast, the direct examiner must never assume any fact, but must base each question upon the witness's previous answers. The cross-examiner's questions, on the other hand, can assume as much as he dares, as long as he rests his questions on some perception of fact. By forming leading questions, the cross-examiner's questions become his statements to the jury. Cross-examination, being a creature of the common law, has no part in civil law tribunals. Its ideal of fair play are no part of a civil law country's culture. Thus, it is found only in the handful of the world's common law countries. To fully appreciate cross-examination as a weapon indispensable to fair play, says Stryker, attend a tribunal in France where cross-examination is forbidden. There, the judge and not the advocate is the cross-examiner. He engages in relentless sarcasms and exhortations that would sicken an American or English lawyer. The French judge is a frank partisan, though not so frank as he might be, and so, having taken a leading part in the conflict, debars himself from ordering an impartial trial. The heart of the common law tradition is a sense of fair play, of which a necessary feature is cross-examination. Indeed, fair play is the fundamental difference between common law and Roman civil law, dominating most all the rest of the world. A mental duel between counsel and witness, the right of cross-examination, says Wigmore, is due to an inborn instinct for fair play, even at the cost of efficient procedure. To forego the defendant's right to cross-examine not only forfeits fair play, but also abandons freedom, allowing false witnesses free rein and one party to substitute its will for law. Its worth, says Stryker, is measureless. No better means have ever been invented for the discovery of truth than that of cross-examination. No more efficacious test of credibility. It is a sword for cutting through and destroying perjury. It is the bulwark of liberty. Let us find the men to man this rampart and hold it at all costs. Amendment 6 continued. To have compulsory process for obtaining witness in his favor. Comment. This compulsory process clause guarantees to the criminal defendant the court's power to compel witnesses by summons under threat of contempt in his favor to either testify or, if such witness is also under danger of criminal accusation, whether innocent or guilty, take the fifth and keep silent. See this handbook, U.S. Declaration of 76, Clause 21, and comment. Amendment 6 continued, and to have the assistance of counsel for his defense. Comment. This assistance of counsel clause demands loyal counsel. Most defendants facing federal criminal trial are, like most Americans, without enough money to retain a winsome defense lawyer. But each federal public defender, being judge appointed, court paid, and under contract at the pleasure of the judge before whom he practices, is beholden to him for his work and pay. Their federal contracts and legislation even barring them from doing any other legal work than that which the court assigns. In short, they are kept men. To make matters worse, by Congress made fiction by legislation, the federal public defender is a government agent unsuable for malpractice. However, legislative meddling with the common law of agency only befuddles a common law agent, owes undivided loyalty to his principal. Thus, as a government agent, a federal public defender owes full loyalty to government. But as his client's attorney, he is his client's agent, owing full loyalty to his client. Common law, however, deems such divided loyalty, no matter how slight, to be disloyalty. Bottom line, no man can serve two masters and be loyal to both. One federal public defender testified under cross-examination that he violated his client's rights in order to curry favor with the judge and U.S. prosecutor. I had to play ball, he said. What goes around comes around. John Taylor, 22nd February 2007. Assistance of counsel is constitutionally sound only if effective. But what can a defendant do if his court-appointed counsel is incompetent, and he is unable, unless he and his family quit eating, to pay good counsel for his defense? Amendment 6's effective assistance of counsel clause has yet to find the dignity our Constitution accords it. There was no widespread need for it until prohibition of alcohol, the war on drugs, so-called, and the consequent unbridled aggression of the criminal law industry. Two changes are needful. First, stop federal prosecution of everything except the 4 crimes the Constitution enumerates: treason, counterfeiting the securities and current coin of the United States, piracies and felonies committed on the high seas, and offenses against the law of nations. Second, use criminal fees to fund, at competitive rates, the insolvent defendant's choice of counsel from among seasoned lawyers. All right, that is the end of this week's call, and we will see you on the next call. Peace and love.